I'm Elizabeth Lincecum, Communications Director at the North Carolina Institute for Constitutional Law. Welcome back to our series, Cornerstone Commentaries. Today our guest is Senior Staff Attorney Jeanette Doran, who will discuss the public purpose doctrine in North Carolina.
What is the public purpose doctrine, and why is it important? These are two questions I get asked quite often. Government can only use tax money to accomplish a public purpose. They can only impose a tax to accomplish a public purpose. So then we're left to wonder, what exactly is a public purpose? And this is the area where it gets a little gray, a little fuzzy. What constitutes a public purpose is evolved. The court has consistently told us that what constitutes a public purpose evolves with scientific knowledge, with the economy, with population. As we as a state evolve, so too does the definition of a public purpose. In fact, the court has said again and again, there can be no slide rule definition for a public purpose. Instead, what we have is a test, long articulated and often repeated. It's a two-part test, and it comes from a case called Madison Cablevision. The first part of that two-part test asks if the governmental act being the imposition of a tax or the expenditure of tax money, does that government act have a reasonable connection with the convenience and necessity of government? The second question, the second part of the Madison Cablevision test asks if the government act benefits the public generally as opposed to special interests or special persons. So that's what we come to. Unless a government expenditure promotes the general welfare and is intended to promote the general welfare, it's not for a public purpose.
Thank you for joining us. And remember, the Constitution is the cornerstone of all law.